Number 53, Pangea Capital Management versus Lakian. Counsel?
Good afternoon. May it please the court, my name is Caitlin Bronner. I'm counsel for Pangea Capital Management, LLC. I'd like to request 2 minutes for rebuttal, please.
2 minutes for rebuttal.
Yes, thank you, Your Honor.
Counsel, how did the divorce judgment here create a debt?
A debt, Your Honor?
Yes.
Well, if Your Honor is asking how it could be required to have been docketed under CPLR 5203A, the answer is provided by CPLR 5203C, which requires that where there has been an oral or written award of an interest in real property, it must be docketed with the clerk of the county in which such property is located not less than 30 days after the earlier real property award. And in that situation, the judgment will relate back to the date of the earlier award.
Isn't the question here really whether this is an award of real property similar like all others? In other words, I think the argument is that this real property always, that the wife always had an inchoate interest in this real property. There was not a transfer of property. It was a division of property. It was a division, it was an equitable distribution of all of the parties' marital property. And in that equitable division, the wife got certain things and the husband got other things, but it wasn't a transfer under the usual understanding.
Your Honor, understandably, well, with respect to the interest between the wife and the husband, that may be so, but that doesn't address the interests of third parties. It's plain, and the New York legislature has plainly spoken on this issue. Musso versus Ostashko was a Second Circuit decision in which the rights of a former spouse arising under an equitable...
But in Musso, there wasn't even a judgment of divorce, and I think it's pretty clear from the Second Circuit's opinion there that was a problem. There was no judgment, and there was no judgment entered, let alone docketed. And maybe there was, I think it can be viewed as everything talking about docketing was really dicta under the circumstances of that case. There was nothing there.
Well,
go ahead.
Sorry, Your Honor. I would say that to the extent that Your Honor may believe that, CPLR 5203 answers the question. Because again, it's specifically...
Isn't 5203 just a response to Musso? I mean, it's the legislature's response to the circuit.
It is a response to Musso, but in responding to Musso...
And there's a couple of problems with that. One, I think Judge Stein just mentioned it's dicta in Musso. Two, it's a circuit decision, so
we're not
in terms
bound.
of New York law, we're not bound by it, even if it wasn't dicta. And it talks about bankruptcy. So what relevance would that really have to have to our decision?
Does CPLR 5203C have as it relates to Musso? Well, again...
No, it clearly addresses the Musso problem in a bankruptcy context. And if that's the rule in New York, then it would address that. But that's not what we have here.
But the legislative history makes plain that it is not, that the docketing requirement is not limited to the bankruptcy context. Specifically...
But the statutory language talks, I'm sorry, I'm over here.
Sorry.
You started out earlier by saying 5203C requires, if we thought this was a judgment, that it be docketed. I think you said that.
I did, Your Honor.
Why does it, I don't see that it requires that. I see that it says if you do that, then you get a certain priority in a bankruptcy.
Well, well, again, if one were to look at the legislative history, it's...
Well, I'm asking about the words of the statute.
Well, the wording of the statute specifically does speak of priority, but it says that in order to have that priority, you must docket. So that suggests implicitly that the docketing requirement of CPLR...
And that priority is in a bankruptcy.
Right.
It's not limited to bankruptcy.
Is it not?
Again, if I may just quickly get to the legislative history.
But let's look at this statute first. It says that created upon simultaneous later filing of a petition in bankruptcy pursuant to the U.S. Bankruptcy Code. So how is it not limited to bankruptcy?
Because, again, it's plain from the legislative history that it is not.
So we would look at the legislative history over the plain text of the statute.
This court has specifically held that it is appropriate to examine the legislative history even where the language of the statute is clear.
But we generally do that to reinforce our interpretation of the statute. So what you would be asking us to do is to say the plain language of the statute is X, but the legislative history is Y, and Y is going to trump the plain language of the statute?
I wouldn't be asking that, Your Honor. Again, CPLR 5203A makes clear that docketing is required. CPLR 5203C confirms that docketing is required, and it notes this in a specific bankruptcy context, but it is consistent with CPLR 5203A in that regard, so it is appropriate to consider the legislative
So
history.
if it applies everywhere, why would they include the language of bankruptcy? What's
I'm
the point of
sorry.
that? What's the point of that, if you're correct, that it applies regardless of whether or not it's a bankruptcy proceeding?
Well, again, because it is a response specifically to Musso.
Yeah, but
it is
I
not-
thought your argument was it's not limited to bankruptcy, so then there would be no point to include it because, of course, it would subsume bankruptcy proceedings
Oh.
and therefore respond to Musso.
Once again, just to be clear, CPLR 5203C alters the traditional priorities that would ordinarily exist when a bankruptcy petition is filed.
Yes,
So
no
that's-
doubt, that wasn't my question, though.
Okay, but again, so to the extent that it does that, it doesn't alter the docketing requirement that already exists in this context under CPLR 5203A. If I may, just quickly get to the
Well,
legislative
but
history.
let's go back to A, all right, and the language of A, and it's talking about judgment debtors. I have a much more fundamental problem, which is I don't understand how you are saying that the wife here is a judgment debtor.
Well, once again, I believe that that is made plain because in Musso, well, if I may, in Musso.
There's no money judgment entered against the husband at this point. or at
There's
any
no money
point,
judgment.
during these proceedings.
No, there's no money judgment against the husband.
So how is, again, how is she a judgment debtor or creditor or, whether it's a creditor or a debitor, a judgment debtor or a judgment creditor? How is she either of those things?
Well, she is treated as someone who has a type of judgment which must be docketed under the statute. And again, that is.
To follow up on Judge Feynman's argument, the purpose of docketing, as I understand your argument, is so that third parties will be on notice, right?
That's correct,
And
Your
of course,
Honor.
to establish priority under lien. But one of the problems here, and really neither party seems to mention this statute, but when I look at the question of how would the judgment creditors be informed of a change in title when a divorce is entered in one county and the property is located in another county like we have here? The answer seems to be in the domestic relations law in section 234, not 236. And in 234, the judgment, where a judgment is recorded in a county where the property is located, in the same manner as you record a deed. And I think it sets forth, if you look at it, it sets forth the process to make sure that those deed protections that you get in a conveyance of a deed protect notice for the other party. And so in other words, I think the law has provided to address the policy question that underlies your concern. I think that 234 and a recording of the judgment in the same as an attachment to the deed takes care of that underlying problem and really undermines your argument. Now, in fairness to you, 234 wasn't in your brief. So I don't expect a great off-the-cuff answer that wouldn't be fair to either party. But I would encourage you to look at it, all right?
Yes, Your Honor.
Okay.
So I want to address some other aspects of the DRL too, and that is that it seems to me that there is a way that potentially a spouse could end up being a judgment creditor subject to 5203A. And that is, for example, if the spouse gets an award of child support or maintenance or some other thing, and the other spouse, and a judgment of divorce is entered, and the other spouse doesn't pay that, the recipient spouse can then go to court and get a money judgment as a judgment creditor, and then in order to establish priority of that judgment, would have to comply with 5203A. But if if that's the case, then why would we need, for example, Section 244 of the Domestic Relations Law, which is what entitles the spouse to get a money judgment?
Well, I think that in point of fact, the point Your Honor is making is the point that Andrea Lakian's attorney has made, which is that DRL 244 judgments theoretically might need to be docketed, but not DRL 236 judgments. I see my time is up. If I
You
may
may
just
continue.
respond, thank you. But the problem and the reason that we believe that CPLR 5203C does in fact confirm that docketing is required here is that Musso was a DRL 236 case. It was not a DRL 244 case. And in response to Musso, the legislature clearly and plainly manifested its intent that in a Musso-type case, the judgment, not the award, but the judgment of divorce, which is the DRL 236 judgment, would have to be docketed to create priority.
And in Musso, there was no judgment, and that's where the requirement of docketing becomes, I think, dicta.
But okay.
Thank you, counsel. Counsel?
May it please the court, I'm Judith Richmond for Respondent Andrea Lakian. Good afternoon, Your Honors. And we are here today, I believe, to confirm that equitable distribution is unlike all other aspects of the law. It is brilliant, and it provides that when a court determines that there is marital property, and they go through the factors, and they distribute the property.
Counselor, the way I see this is that at bottom, okay, a judgment creditor can only reach the judgment debtor's assets, correct?
I agree.
So the way that I see this is that the judgment of divorce, once it was entered, made these proceeds no longer the husband's assets. And so it's really not, whatever you want to call it, judgment debtor or judgment creditor or equitable distribution, it really comes down to that very basic rule that because of equitable distribution, that no longer belongs to him.
I agree 100%. It has nothing to do with being a judgment creditor and judgment debtor. She is the owner of the property. As of the entry of the judgment of divorce, he is the owner of his property as of the judgment of divorce, and his creditors, Pangea or others, have a right to go against his property, not her property. She owns her property. She's not a judgment debtor of the husband, nor is he a judgment debtor of the wife.
But there could be circumstances, and I alluded to them earlier, if there was something else in the judgment that directed him to pay her something or whatever, and then she went to enforce that right and went to a court and got a judgment, that would put her in a different light, correct?
I agree. If he had owed her, or a spouse owes another spouse, let's say interim support, and they don't pay the support, that is not equitable distribution. That is a payment of a debt, and therefore you get a judgment. That is far different than being an owner under equitable distribution, under property that's distributed.
Or a distributive award. If he had a business and they evaluated the business and said she was entitled to some dollar amount as her interest in that business, and he didn't pay her that distributive award, then she could get a money judgment, correct?
Well, it was her ownership interest under the distributive award, and then how she proceeds to obtain that ownership interest. There are numerous ways.
Well, this case is about real property. This case is about real property, and I understood your argument to be that upon the entry of the judgment of divorce, that is a judicial determination and pronouncement of title.
Correct. And also, Your Honor, in this situation, she was the beneficial owner of a trust. She had an increased interest in the division of the trust assets of when it was sold. So it is not necessarily real property.
I'm sorry.
So it's title ownership in the what?
Well, she has a greater interest in 62.5% of the proceeds of sale plus $75,000. That's her money. And she, prior to the divorce, she also had her independent interest, and then after the divorce, that is her
So
property.
then to clarify, so you're not saying it's the title in the property that
Changed.
gets sold, it's the interest in the proceeds from the sale.
She had an interest in the proceeds from the sale. She also had an interest in the property. But in this...
Interest in the property, a title ownership?
Well, GEMS 2
Okay.
had the title, and she had an interest, she had beneficial interest in that, and that
So
was
this divorce
increased.
judgment contemplates the sale of that property and the future distribution of the proceeds based on their ownership interest,
Yes,
as held by the court, right?
Yes, the property was already on the market at the time of the agreement and then the judgment of divorce. It was, and there were provisions of how they each had a right in the property and the distribution of the assets upon the sale.
But is the interest in the property an owner's interest? That's what I'm trying to clarify from
Well, she
your
had-
argument.
She was an owner.
Okay.
She owned both the property, she owned the proceeds of sale upon the sale. She had an interest in, as a beneficial owner of the trust. So under any circumstances, she was an owner. And under all circumstances, she was an owner.
It seems to me, counsel, that trust kind of clutters the issues here factually, right? But for us, in the certified question, they've asked us if an entered divorce judgment grants a spouse an interest in real property. So we are assuming in that question this is an interest in real property, right? And I think there are different cases, and I think they're cited in the briefs, that say a distribution, whether it's sales proceeds or dividing the property, is an interest in the property, right? So the trust
Yes.
kind of adds an interesting layer to the facts of this case, but it seems, as I read this question, what the circuit is asking here is, when you grant an interest in real property, then what happens here? And you don't docket it, what's the effect, right?
Well, they are, but in this situation, one of the, in this situation with Andrea Lakian, she had an interest in the trust proceeds, and the answer, though, with respect to any property under equitable distribution, they don't make a distinction. That is one of the basic foundations of 236B.
Sorry to interrupt you. Is the import of your argument that the docketing priority doesn't matter here because once the judgment of divorce was entered, the property was separated, and at that point, even if Pangea had a priority, all it can levy against is Mr. Lakian's share. Is that what you're saying?
Correct. She was an owner. She wasn't a judgment creditor, so she doesn't docket.
But even if we were giving a priority to Pangea, it's only against, once the divorce judgment has happened, it's only against Mr. Lakian's share. Is that what you're saying?
Correct.
Okay.
Correct.
So
She
the
owned her
docketing
share.
priority in some ways doesn't matter.
She owned her share, he owned his share, Pangea has a right against his share. They were judgment creditors post-divorce against his share, which is the foundation of equitable distribution.
So,
That once-
so let's say we disagreed with you. What would the public policy implications be for divorced individuals who apparently in New York have not been docketing their judgments?
A horror, Your Honor.
Describe, how do you mean that?
It would potentially undo thousands of awards because 236, equitable distribution, says you're an owner. That's how the courts have interpreted it for 40 years. If now all of a sudden the court were to say, by the way, you're not really an owner, you're a judgment creditor, and somebody has come in over the last 10 years or so.
And has priority, right.
Who has a judgment against your ex-spouse, but you have the property and you've owned the property, they could come back after all those years. It also undoes all the future of equitable distribution, because 236 says it doesn't matter how title is held. Then you would be saying, well, yes, if it's personalty, you're the owner. At the judgment of divorce, you're the owner. But if it's real property, you're not really an owner, you're a creditor, which is not what 236 says. So you would be undoing the entire concept of equitable distribution. We would be going back to a title state and make...
Okay, I think we have, I want to ask you about something that is not this case, and I recognize it's not this case, but I'm a little worried about it. And that is, part of your argument is built upon the entry, right, and the timely entry here of the divorce judgment. But what happens, and I see this as, maybe a future case, when there's a divorce, and the judge comes down with a decision after trial and divides up the property under equitable distribution and directs entry of the judgment. And there's a delay in the county clerk's office for weeks and weeks and weeks, and it may even go beyond 30 days for bankruptcy under this. Then what are we going to do?
Well, I think that the courts have already basically determined that, yes.
And assuming that, Pangea or whoever the creditor is has, in the meantime, docketed.
Well, they have, right. I mean,
I guess what I'm getting at is the focus on entry.
that is what the courts have said, that there's an inchoate right, that you have a protectable right during a divorce, but when the judgment of divorce is entered, you are an owner. Your ownership vests, and that is it.
So if the county clerk delays in entering, that spouse is unprotected?
Well, you have, I mean, there are potentially, I mean, ways of, I assume, of getting potential, there are restraints in the matrimonial law and in the equitable distribution law. I certainly that 5203C was enacted for one specific purpose, and that was where the judgment, where the divorce had been on the record and it hadn't yet been entered. Right. And so the court said, both in commercial cases and in matrimonial cases, and I believe docketing had to do with commercial cases, not with matrimonial cases, but you could then be considered, you get an extra 30 days. Does the legislature then...
So we'll have to cross that path with the legislature down the road.
That is down the road, but for this case and for all other thousands of cases and all other thousands of litigants, the entry of the judgment confers vested, absolute, complete ownership. You go, one, spouse, ex-spouse goes their way, another ex-spouse goes their way. That is what is, frankly, partly so brilliant about it. You are not a judgment creditor in those situations, and you have the ability to get on with your life economically and other ways. And that is what happened in this case.
Thank you, counsel.
Thank you, Your Honor.
Counsel, what about respondents' projection that if we were to decide in your favor, this would be a horror?
That's simply not so, Your Honor.
Why
the
is
short
that?
answer is that the decision in this case will apply to a very narrow class of cases, cases in which the property at issue is held in a trust, in which the divorce judgment doesn't require the property to be deeded outright and the trust dissolved.
So you're saying if this property was in the husband's name, but same terms of the judgment of divorce, that would be a different result?
Well, I'm simply saying that, again, the unique facts of this case are that the property is held in a trust.
See,
and it wasn't
what I'm
deeded-
trying to get is, I don't see why the trust makes any difference here.
Well, also, the property is located in a different county, and as...
Again, is that's so unusual? I mean, the parties may have been separated for a long time. One lives in one county, another lives in another county, someone may live in another state.
And is further evidenced by the fact that the Second Circuit certified this question because there were simply no decisions of this court. In fact, there are only 2 trial court decisions that have addressed the intersection of the areas of law that are manifest on this appeal. If I may
That may be because nobody raised it before, but.
If I may just quickly respond to 2 other points. First of all, with respect to the focus on entry as opposed to docketing, I would note that the legislature has made plain that, quote, under CPLR 5203A, the Supreme Court's award of the marital home could not be enforced until docketed. That is referring to the Musso decision. So clearly it was the moment of docketing in Musso, not entry, which would have conferred upon Tanya Oshtaschko her rights. Additionally, I just wanted to note again, the legislature does not distinguish well, it specifically provides that in both matrimonial and commercial actions, docketing affects legal ownership, and the docketing date determines the seniority of competing property interests. See CPLR 5203A. That is in the legislative history of CPLR 5203C. It plainly indicates that in both matrimonial and commercial cases, docketing
That clearly
determines
comes
seniority.
from the language in Musso, right? I mean,
Excuse me, Your Honor?
we can assume that language comes from that comes from the language in Musso.
It is the legislative response to Musso, Your Honor, specifically, not from the language itself in Musso, and that confirms, in my respectful opinion, or it confirms that we believe that clearly the legislature was making plain in response to Musso that in all matrimonial cases, whether DRL 236 or DRL 244, docketing is required in order to confer, in order to determine seniority, including in matrimonial cases.
Thank you, counsel.
Thank you, Your Honor.